Now, earlier scenario, the IT Act was there. It still is there. India's first major cyber law focused on e-commerce, cybercrime, digital signatures, etc. But no comprehensive personal data protection mechanism existed in the IT Act. And Section 43 and 66 dealt about hacking, unauthorized access, etc., but not misuse of personal data. So, data was never the cornerstone. The IT or the use of computers or the hacking or access controls were there, but data per se as a subject wasn't there. So hence the need. They were also in Section 43A rules called Sensitive Personal Data or Information Rules 2011. And those were good, which said that companies need to adopt reasonable security practices and procedures, etc. It introduced a definition of sensitive personal data, which is, say, health records, financial data, even biometrics of a person, etc. It had small provisions about consent and the fact that privacy policies need to be made by the organizations, and they need to probably be ISO 27001 certified, etc. But it applied only to body corporates engaged in commercial or professional activities, not to government, not to NGOs. Only body corporates engaged in commercial or professional activities. And also the provisions related to consent or privacy policy or certifications like ISO were not very clearly laid out in terms of who needs to do it, whether to be done by all companies or certain companies. No concept of significant data fiduciaries, which we'll cover today. So many concepts were missing, and anyways, it wasn't tightly enforced also. So I think it at a high level, I mean, large good organizations would have implemented in spirit and anyways done what the IT security and ISO standards do. But the middle sized organizations or organizations which are not as serious about these things, I think it all reduced to getting a 3 pager or 5 pager privacy policy done and uploaded on their website, and that was the compliance. So I think what is required is a much more holistic approach of how data, where all data is flowing in our organization, what is sensitive data, how it needs to be protected, what kind of safeguards we need to have. That is what the act talks about.
Dr. Sumit, one question I had
Yes.
here.
Yeah, please.
I could see in the presentation it was mentioned that Section 43A of the IT Act has been repealed.
Yeah,
So,
yeah.
as far as I remember, it is when the body corporate is liable to pay damages in case they're negligent in protecting the sensitive personal data. So now do you mean that it is repealed and the DPDP Act, along with its penalties, is something that would prevail and not
Right.
the earlier one?
Absolutely. No, right observation. And I think I missed talking about the thing which I had highlighted in the footer. Yes, by coming of the DPDP Act, 43A has been repealed because this dealt with these reasonable security practices, etc., sensitive personal data. Now, since all these subjects are dealt, that one section is now being replaced by the whole act in such a way by laying down a detailed framework, and not just the framework and safeguards, but also the penalties. So, yes, everything related to data so that there's no duplicacy and confusion. 43A has been repealed of the IT Act and replaced by the whole DPDP Act and the rules.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.